दिख रहा है? हेलो।
दिख रहा है, दिख रहा है। কেউ জানো যে কি করে সবাইকে মিউট করা যায়? মানে একটা অপশন থাকে না যে যে ঢুকবে মিউট থাকবে।
বলছি তোকে, আমি টেক্সটে বলছি। সেটিংসে যা, সেটিংসে যা, পতত্রী সেটিং, এই তিনটে ডট আছে ওখানে, সেটিংসে যা। চেয়েছিস?
দাদা তুমি বলতে থাকো, আমি মিউট করে করতে থাকছি।
তুই মিউট সেটিংস না একবার তুই অন কর, যাতে আমি বুঝতে পারি যে হচ্ছে কিনা।
আচ্ছা আচ্ছা আচ্ছা, ব্যাকগ্রাউন্ড নয়েজ আসবে ওই জন্য, ঠিক আছে।
অসুবিধা নেই, কোনো অসুবিধা নেই, এখনো শুরু হতে।
সেটিংসে গেলাম।
সেটিংসে যা, সেটিংসে গিয়ে ওখানে দেখ হোস্ট ম্যানেজমেন্ট, পেয়েছিস? হোস্ট কন্ট্রোল, হোস্ট কন্ট্রোল, হোস্ট
আমাকে
কন্ট্রোল।
তো জেনারেল দেখাচ্ছে, ভিডিও দেখাচ্ছে, অডিও দেখাচ্ছে।
অর্গানাইজার কে? মিটিং এর
আমি
অর্গানাইজারটা কে?
আমি 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 আমি
জেনারেল দেখাচ্ছে,
জেনারেল দেখাচ্ছে, অডিও দেখাচ্ছে, ভিডিও দেখাচ্ছে, ক্যাপশনস, রিঅ্যাকশনস।
অডিওটা দেখ, অডিওটাতে মিউট অল অপশন আছে?
না, মাইক্রোফোন আছে, মিউট অল দেখাচ্ছে না, দেখাচ্ছে না গো।
মিউট অল আসছে না?
না।
কম্পিউটার থেকে জয়েন করা?
হ্যাঁ, ল্যাপটপ থেকে।
হোস্ট কন্ট্রোল বলে কোনো অপশন আসছে না?
আপাতত আসছে না
আমাকে
দাদা।
আমাকে আমাকে পার্সোনাল চ্যাটে একটা ছবি তুলে পাঠা একবার।
ও দাঁড়া দাদা, পেয়েছি পেয়েছি পেয়েছি। হোস্ট কন্ট্রোল একদম উইদাউট সেটিংসে আছিল।
হ্যাঁ, ওই হোস্ট কন্ট্রোলেই যা, হোস্ট কন্ট্রোলে মিউট অল করতে পারবি যখন চাস। হ্যাঁ,
তো দাদা এই কেসে আমি যদি সবাইকে মিউট করে দিই, তাহলে যারা কথা বলবে তারা কি করে কথা বলবে?
Good morning, everyone. We'll start in a bit.
Good morning. Are we ready?
Yes, yes. Good morning, everyone present here. I'm Shalya Anaz, a trainee at CPC SATYA Incorporated Law Chamber. First, I would like to introduce our chamber. It is founded in 2024. CPC SATYA is a boutique law firm led by advocate and policy consultant Chandril Chattopadhyay and advocate and tax consultant Argade. The firm begins together. They combine expertise in constitutional law, taxation, commercial disputes, regulatory litigation, and art law advisory, among other areas. What sets CPC Satya apart is its client-first approach, strong emphasis on legal research and policy advocacy, its commitment to mentorship for budding professionals. Within a short span of time, the chamber has earned trust and recognition, especially as a thought leader emerging from Eastern India. Established by two first-generation lawyers, CPC Satya is built on trust, collaboration, and innovation, who offering a rare companionship in a competitive profession. The firm actively, hello, am I audible?
Yes, you are.
Supreme Court acts as a council of chamber in Delhi and Mumbai and actively involved in social outreach initiatives, including work with Rotary International. And now I would like to introduce our coordinators for today, Patatri and Shumojit, who look after the technical aspects of today's session. And if there's any glitch, feel free to reach out to them. It's truly an honor to moderate this session of the Knowledge Series Bootcamp, which is designed to unpack what we truly call the Holy Trinity of every law student's journey: legal research, paper presentation, and moot court. Today, I'll be moderating the first two sessions, that is legal research and paper presentation, which forms the academic foundation of our legal career. As a student myself, I understand how intimidating it can be. It can feel at the beginning, not knowing where to start researching, struggling to write your first research paper, or the fear of speaking in front of panel. I can promise you today's session will not only answer those questions, but also inspire you to overcome those fears. Now I would like to introduce our speaker. Our mentor for today's session is someone I would personally call the master of legal research and paper presentation. It's an honor to introduce Mr. Rajat Shandaliya, who is research assistant at Jindal Global, who is currently pursuing his PhD at Symbiosis International University, Noida, and also serves as a research assistant at Jindal Global Law School, where he contributes actively to academic research. He holds an LLM from Jindal Global Law School and completed his BA LLB from AMU. He has authored and published more than 30 legal research papers, each reflecting academic precision and Okay. Served as a judge in over 18 national level competitions hosted by top law schools, including HPNLU, Manipal University, Kanpur University, and IILM University, Greater Noida, and several other prestigious institutions across the country. Sir, we are eager to hear from you. Not only how to structure a good research paper or deliver an engaging presentation, but also how to overcome real fear that most of us deal with like public speaking anxiety, lack of access of resources, or doubts about originality. The floor is now all yours, sir. Thank you.
Okay. Thank you for such generous introduction of mine. So just before we begin, I'll just take a moment to ask you people, am I audible and visible properly?
Yes, sir.
Okay. Let me just present my screen. Yes. So is my screen visible now?
Yes, sir.
Okay. So thank you very much to the chambers and my dear brother for this opportunity. So since this segment, the session today is divided into 3 segments, so we'll have a structured approach towards it. So now to begin with, I'll start with legal research, which is the fundamental thing that we talk about being in the profession of law, right? So the most important thing is that what actually legal research is and what is its need and what is the benefit of acing legal research, I would say. So see, research is, in my opinion, research is something that is inseparable part of the legal profession. No matter if you are a judicial aspirant, if you want to be into academics, if you want to go in a law firm, if you want to pursue your corporate means if your career in corporate or even litigation, research is something that is going to be with you lifelong if you want, if you are in the legal profession and if you want to continue this profession with full integrity. So when we talk about legal research, in my own words, I would say that it is the process of identifying, as you could see in the slide as well, that it is the process of identifying and retrieving information which is necessary to support legal decision making. Why I am saying this is that see, at times it is not always possible for a lawyer or a law professional to remember each and everything. So legal research, I would say, it fills that gap. It helps you navigate and it helps you turn the fate of the cases entirely on its head, because if you get something on your point, then you have the edge over the other party or the opposite party that you're appearing against, right? So this is it. What is legal research is, it is a formal and systematic process, as I've mentioned. And then in simpler term, I would say that it is a systematic mechanism. Why I say it to be a systematic mechanism is that we before we even approach doing legal research, we should understand the fundamental of legal research is that we should understand that what is the issue at hand, what is that we are searching about, what is the answer, what is the problem that we are looking for, when we are finding an answer to a question that we have at hand. So legal research is very essential in in solving a problem that we have. And then if you do adopt a systematic approach towards doing legal research, I am sure that you will definitely have an edge over your other counterparts, no matter in whichever domain of law you practice or you work into. Now, why legal research is important? We have talked about legal research. It's about finding the answer of the legal proposition that we have have at our hands. Now, why it is important is that it, as I've said, that it serves as the bridge of the absence, between the absence of knowledge and the answer of it. So why legal research is important? It's very simple. It gives you that confidence. It gives you the answers of your legal questions that you dive into while you are preparing for your own side or your own case on different basis depending upon its complexity. Now, why it is important, I've divided it into broadly 3 points, but this is not again exhaustive. This is, it adds on to go on, so on and so forth. Legal research helps us in finding the appropriate case laws and dive into the concept of law. Why I say all this, both the points initially is that the first and foremost thing when we navigate through research is that, you understand that while we are searching for something, what answer we are looking into. And if you are able to understand the concept while researching, you will be able to understand that what is the exact thing that could favor you, or that could give you an insightful answer of what you are inquiring about. Okay, so not only it gives you a stronger case, but it also helps you to understand what law is, right? Which is a thought of the analytical school of law, what law is. Okay, and again, the last point on this slide is to draw an easy and useful relation between cases and statutes. We all have studied law, hai na? But the thing is that it depends upon us, and it is our fundamental responsibility being law professionals that we are able to apply the principles that we have at our hand, that we have read in the textbook in the law school, into the real life cases that we handle as professionals, or into the real life setup, no matter in whichever domain of law we practice, right? So this is something that legal research comes into picture, and this is where legal research comes into picture, and this is where it builds you as both as a professional and as a person, I would say. So this is the fundamental requirement of why legal research is important. Not only it enhances your personality as a professional, but it also transforms your outlook towards the area of law or the domain of law. The most important thing which it develops is that it gives you the power to think critically, right? Let me give you an example here to everyone who's there in the meeting today, that if let's say a senior advocate says something, right, or if an experienced person says something, so if you are having the ability to think critically, you will know about, and you will inquire about on what basis that person is trying to put forth his argument. But on the other hand, if you're not aware of how to go about things, you will just say ki whatever the other person who's experienced to me has said, it is correct. But this is not the case. Once you hold your command in research and inquiry, you definitely get an edge, and you definitely develop that power within you to understand and decode the reasoning behind everything. So this is why legal research is important, being a law professional, no matter in whichever domain of law you are. Now, different methods of legal research. So these are just pointers that I've mentioned. I would just like to give you a structure of what are the different types of legal research. The first one is empirical, and the second one is I would say descriptive or non-doctrinal, right? So I'll bifurcate between these things. So when you talk, or we can go on with the slides only, there's no problem in it. When you talk about analytical research, and as I told you that analytical school of thought is something that goes on to inquire about the nature of law. So here also when you use this particular methodology, which falls under the doctrinal analysis, okay, so here you tend to go on to the reasoning of law and what it actually is. Okay. Now the second part is the conceptual legal research, where you dive into a particular and specific concept of law, and then go on to develop your reasoning, and you go on to develop to give your own personal and original input regarding any concept of law or any proposition of law, I would say. Now, when it comes to descriptive legal research, descriptive is when you write on in a descriptive nature. Descriptive nature in the sense you go on to explain something which is already existing there, which is you're not specifically contributing. You may or may not contribute something new, but you are describing something, a concept, a proposition, or maybe a case law or something in a descriptive way. So what that would do is that you would now there might be a natural question in the minds of all the listeners today, that if you're not giving something new, then what is the point of doing descriptive research? The point is that descriptive research allows a researcher or a person who's writing something to expand his or her own detailings about a particular concept, his or her own knowledge about a particular concept, and eventually the outcome is then shared with the audience to give them a wider perspective in all at one place, right? We talk about now there are various apps and companies that are trying to give in services which are all in one, sort of compact. So this descriptive type of research gives you uh, you know uh, uh, an edge when it comes to collection of knowledge all at one place, right? Now coming on to the most important next segment of legal research, or the next method, as I say, is the empirical legal research. Now you need to understand that empirical legal research is the kind of research where you go on to the field and then collect data, right? Now what is data? Fundamental question, what data is? Data is that whenever you are contributing to specific area of research, you always tend to validate your research findings through the data that you collect, going either on field or off field. And then what happens is that the researcher goes on to verify the relationship between the data collected and the research conducted, and based on the coherence or based on the results, results might not always come out to be in your favor. There are researches that have all obviously seen the different fate as well. So empirical research is the kind of research where you collect data. It's about numbers, it's about statistics, it's about all the graphs and all the inputs that we receive from the stakeholders, from the experienced people who are there in the industry. And then we go on to corroborate the same with the results of our study, or the findings of our study and the theory of our study. And when all these things get completed, you get satisfactory answers as planned. Okay, and the triangle is completed, you are successfully set to conduct an empirical study based on any proposition or any topic of law that you inquire about and or that you research upon. Now moving on to the quantitative research, which is I would say a sub part of empirical research. As the number as the name itself suggests, that this study involves numbers within itself, and it talks about quantity. When you talk about quantity, you can even note this somewhere, that when it is quantitative, you need to quantify. And when you quantify, it becomes easy for everyone to understand it. It's talking about numbers, it's talking about values, it's talking about the mathematical calculations, the formulas, to derive upon, or sorry, to reach upon a particular conclusion of your research. So right, this type of research, the quantitative legal research, is usually applicable in cases where you need to draw the relation of let's take an example, that if we are calculating that what amount of let's take an example, what amount of water connections does a village need. So in order to quantify everything, and in order to map and track the progress, we will use quantitative method of research, so that we could quantify everything in numbers, that these are the total number of houses, these have the water connection in a particular set of village, these many houses don't have the water connection, so there would be a requirement of the same. So quantitative legal research is it's all about numbers, and it gives you a fair idea when you can actually measure the quantum of your research. And qualitative legal research is a subset of conceptual legal research, where you extensively and in detail examine the statutes, the secondary and primary material that you have. And when I talk about secondary and primary material, I would just like to take a moment to explain upon the same, that the primary material is the material which is first hand, which is authentic, right? All your bare acts, all the websites of the ministry, all the press releases from the side of the government, these are treated to be the primary material. And when you talk about secondary material is something which is written by someone who's an expert in the field, someone who's researching upon in a particular field, but it is not coming directly from the source. And when I say source, it means the origination of that particular point of law, question of law, or for that matter, any particular, I would say, question. And just to clarify this, I would take a moment that let's take an example. There are two press releases. Let me give you an example of the recently concluded Operation Sindoor. That whenever there is a press release from the side of government, so it becomes our responsibility as citizens to take that to be authentic and to discourage every other source, no matter whichever media outlet has said that, or no matter whichever newspaper has said that, but we would always rely upon the authentic source, which is the press release from the government of India. So that press release would be considered to be your primary material while you research or while you read about it. And all the media houses, all the newspapers, then the same information becomes your secondary research or secondary material, because that is not coming directly from the source. So this is the difference, and I hope that I've been able to clarify upon the same. Now, stages of legal research, this is very important. First is planning your research. Second stage is implementing your research, and third stage is presenting your research findings, which I'll also connect with the second segment of paper presentations that I'll be talking about in a short while. So when you talk about planning your research, it becomes fundamentally very important that you understand that what is the thing that I want to inquire about, what is that thing that I want to look into, what is that new thing that in my inquiry and my research I'll be able to contribute to the existing pool of research, existing pool of knowledge that we already have. And that is where you stand out as a researcher. The more nuances that you touch upon, the more inputs that you give, and the more result oriented research that you have, the better impact you will create through your research and your inquiry process. So while someone plans the research, it's important that we understand that there is a certain set of structure that is to be followed while you do research. And then I'll towards the end of the presentation, I'll also talk on this, and I'll show everyone that what is and what should be the standard format of a research paper or a research based write up. So when you plan, always look into 2 to 3 things. That is, what is your research question, what is that exact thing that you want to research upon, and what is the method and the process that you're going to follow. All these methods that I've told you are to be implemented within the research setup of yours, and the same is then going to be affecting your research. And again, the last important thing, what would be the result and the impact of my study. It has to be impactful, it has to be read by readers, it has to go to a wider audience if you want to be a successful researcher. So it's about planning. Always ponder upon these 3 things before you start any research, and based on that, plan and execute that same thing in a better fashion. Now, research implementation. When I talk about implementation, it means that how the research findings are to be implemented, are to affect the original society at large. Okay, we have written something as researchers and academicians, but what is the impact? That is to be seen, right? So when you talk about implementation and impact, implementation is that how you are going to apply your research into the real world scenario, into the real society, and based these two words go hand in hand, implementation and impact. The impact assessment is also important, that the implementation, whatever we have brought into the society through our research, is impacting the population in which way. Either it is positive, either it is negative, either it is a welcome step from the side of the population, or it is not so. So these are the things when we which we see when we talk about research implementation and impact. And again, the presentation of research finding. When I say presentation of research finding, is that you finally conclude something in your research based on its planning, its writing, and its implementation and impact. And based on that, you say that, see, this is something that I've conducted, and based on my theory and my practice, now my study has turned out to be successful in this particular set. And when your research turns out to be successful, then obviously you have that sense of fulfillment, and then that sense of proud within yourself, that yes, I have created a difference. At least lives are getting affected, lives are getting something positive out of my research, and it goes on in the same fashion. Now, moving on to something new, the writing part of the legal profession, which is also important. Abhay, the question is that we all have done research. Okay, we know how to do research. What is to be followed while you do research. You structure your research, you plan your research, you talk about its implementation. But again, how to do? Okay, how to present and how to write. This is something that I'll talk in this segment. See, when we talk about legal writing in legal profession, then there are basically two types of writing. One is the academic writing and one is the professional writing. When you talk about professional writing will include all your legal documentation, your contracts, your plaints, your written statements, okay, all your legal notices, their replies, their counters. So these are the things and documents that we use, within the court setup or within the legal setup when you are a practicing professional. But the second, this is the one type of legal writing, in the profession. But the second part of it is the academic legal writing. Academic legal writing is where you present your ideas through research paper, you present your ideas through short research articles, review papers, critiques of particular papers. So, and you go on to contribute into the academic, I would say, setup and academic circle to enhance the existing pool of knowledge. And that is something which is fundamentally different from the court-based legal documents, because in academic setup you're only concerned about the theoretical aspect of a particular law, and based on, and when you talk about academic writing, it might or might not be always only theoretical. Based on the theories that the academicians and the researchers propose, there are always various projects that funded or non-funded projects that are executed, that are looked into, and then which are ultimately met with their objectives based on the suggestions that have been advanced by the researchers. So you need to understand that the court-based documents or the court-based legal writing is different, and where you draft your plaints, your written statements, as I mentioned. So that there also you are writing something, you're presenting your own flow of ideas, but academic writing is fundamentally different, as I have just mentioned. Now, different formats, as I told you, the different formats of legal write-ups this is I have taken an example from the academic point of view. So you all have heard about, you must have heard about the blog part. So blogs are typically, they're short forms of legal writing or a legal piece where, and I've categorically mentioned the word limits also. Short research article is, I would say, short research articles are a piece of writing where you only, you usually use the descriptive form of legal research to bring all the knowledge at one place about a particular topic. And these word limits are not strict and are flexible from platform to platform. Okay, then the third thing is that there is long research papers or articles which typically range from 4,000 to 10,000 words. And here this is something that I would say the core variety of legal writing, where you follow a definite structure, which I'll definitely take a moment to share with everyone, and the format of it, so as to give you a formal idea of how your structure should look like. Then there are, and one important thing is that when you write long research papers, here you probably tentatively or probably I would say work on a particular idea based on concrete evidences, and here you propose something I would say impactful, that based on this point of law or this point of research, I believe, or the researchers believe, always make sure that you are not using personal pronouns while you write. Always use the researcher, the academician, okay, the stakeholders. Always write from a neutral point of view, and don't use personal pronouns. Personal pronouns are restricted while you are into academic writing. Now, legal opinions, these are usually short, okay, and this could be upon anything. On you could write your opinion about any judgment, any legal policy that has come into any framework that has been proposed. So this depends. And then again, another form of legal writing is the book reviews, where you critically examine someone's else work, or I would say particularly a book, and then you propose that what are which things are positives and negatives, and you critically review the points which are mentioned in that particular book. And when it comes to review papers, then let me tell you what review papers are first of all in a minute. That review papers are the already I would say that review papers are the response to someone's already published work. Let me give you an example that if I write something, okay, and then based on my paper, someone also someone among you reviews my work, and then they present that these things were pointed out, and I disagree or I agree with the same, and you critically examine my work, all my papers or all my write-ups or one of my write-ups of among them. So this is basically the functioning of review papers. Now, the chronological structure of a legal write-up, this is very important. I would request everyone to please yeah. Yes. So now I request everyone to please take a screenshot, because this is the standard format. Okay. I hope the screen is visible properly.
Yes, sir.
Yeah. So everyone, please take a screenshot. I'll take a moment to talk upon it in detail. So when you talk about of a legal write-up, the first and foremost thing is the abstract. What is an abstract? See, abstract is something that gives you a fair idea of what actually flow of paper is going to cover, right? It is a very brief idea of if we talk about the standard length of an abstract, 250 to 300 words, but it might extend upon up to a limit of 500 to 700 words if the platform that you are submitting a paper for, specifically demands the same. Okay. Now, after you've written your abstract, you give each and every detail that this is the idea you're working upon, this is the methodology you're going to adopt, and these are your tentative findings that you wish to propose or you wish to research upon through your paper and through your academic writing. Now, moving on, after you've written your abstract, you need to structure your paper well. So structure means the abstract is nothing but it's just a brief outline of your paper, I would say. Now, moving on to the introduction part, this should be the first segment of your research paper. And in my opinion, see, it is very subjective, but I usually prefer writing my introduction within let's take an example. If I'm writing a 5,000 word paper, so I would conclude the introduction between typically between 700 to 800 words, and the ideal structure should be writing your introduction within 3 paragraphs. So this is what I follow, but this is again very subjective. Now, moving on to the next segment, that is the that you all might be thinking about is what actually literature review is. This is something which you call a technical jargon if you are unaware of the same. But literature review is, I would say, the most important thing of your research paper, because literature review is something that you do upon the already existing papers or already existing literature upon the same topic to frame and to support your own research. Okay, because see, we all are humans, right? We cannot calculate and we cannot know everything by looking at our own idea. So it's important that we shape that idea also, and that is where literature review comes into picture. Literature review, in simpler terms, is the systematic evaluation of the already existing material on your particular area of research that you are researching upon. Now, research methodology, as I mentioned, that it is the kind of method that you use or you adopt to conduct your research, be it doctrinal, be it non-doctrinal, or so on and so forth. So through this methodology, you plan to execute something and you plan to bring something which is already not there in the typical legal setup or the typical legal scholarship, which we call. Now, moving on to the next thing, hypothesis. Hypothesis is, I would say, in simpler terms, is a statement that could be tested. Let me give you an example that you are, let's take a very simple example here, that you are, wanting to research upon child marriages, for example. So you will create a statement which could be tested around that same thing. When I say tested, it means that if I'm assuming something at the start of my research, it may or may not be true. Okay, so it is basically a fundamental statement which defines the trajectory and the flow of your research. Okay, it's a testable statement that most of the researchers or most of the academicians work around to frame their research in a particular way or in a particular flow. Now, moving on to the next thing, the main body of your paper or article. Main body might is the wrong word here, shall contribute to the entire structure of your paper, and shall also be free from, I would say, grammatical errors. This is a major turn off for all the reviewers and all the editors when they go on to review your papers. So your body should be something which is structured. You can use numbers as well. You can number the headings and then go on in the same way. and your towards the end comes your conclusion, your suggestions, or the results of your study that you conduct, where you conclude that based on the entire study, these are my conclusions, and the conclusions or the suggestions or the results on this particular point of law or this particular aspect of my research in so and so and such way, right? So this is the fundamental structuring of your paper, and this should ideally be followed. But again, just to give you a fair disclaimer, I would say this is not again rigid. It depends upon the demand and requirement of the platform that you are engaging your you're wanting to engage upon based on your research and based upon your inquiry that you've conducted. So now, what are the factors to consider while you've researched upon? Now you have utilized your research methodology. You know what is research. Now, what are the now your research paper is ready, and after you have written your conclusions and you've formatted your paper and everything. Now it is important for you to understand that you should not go at unauthentic places to get your paper published. Always make sure that whatever you have written should be published at a place where it holds certain value. It gives you a sort of recognition. All my papers which I have published, I have made sure that they are published at a place which is recognized, which is holding certain value. I'm not saying that everyone becomes a pro researcher at the first go, or aces at it. It's a gradual process, and we all learn through it. And if I talk about my personal experience, it has taken me over 6 years now, because I've been active right from my second semester as far as I remember, and it has been till date that I've actively been into extensive legal research and writing. So this is something that I can share with all of you with full confidence. So now these are some important points that I'll mention, and this is again a slide to be taken screenshot of. First of all comes up, first important thing is the reputation of the platform in the market, right? So if you get your paper published or your article published at a platform which is lesser known, or which is not known to general public, then what is the I'm not saying, or I'm not discouraging anyone. We all learn through going by the process, but always make sure that you keep a check on the reputation of the platform. Number two is that whether the platform adopts a peer review process or not. What is a peer review process? For those who don't know, for those who know, it's very good. For those who don't know, peer review process is the process where your paper or your article gets thoroughly and critically examined or reviewed by industry experts, or who are already who already hold certain position in their own I would say professional setup. So, and if it is not peer reviewed, it's not authentic. So this is something which is to be kept in mind while you publish your work. Now indexing is something that there are multiple indexes that are the journal has to be a part of. The most prestigious indexing, I would say, is Scopus and Web of Science. But then the Scopus indexing also requires a different level or a different standard of research, where everything has to be aligned in a logical way. Okay, so to all the beginners who are starting to write, who are wanting to build upon their career based on research, always at least look for some platform which is peer reviewed, and then gradually go on to build upon the same based upon your experience and your learnings that you take from there. Now again, the next important thing is the advisory and the editorial board of the platform. This is something that you could check upon the website of the journal, and based upon the same you could form your opinion that which journal is suitable and which journal is more credible. And always make sure, please don't fall prey to all these fake journals, or all the journals who give you promises to publish within 2 days, 3 days. This is not possible. So always be wise while you submit your work to a particular journal. And again, the impact factor is something which talks about which gives you a fair idea of the authenticity of journal. And I would also urge you personally to look into the time of the platform, since it has been active. The older the platform, the more trustworthy, and the older the platform, the more, I would say, authentic it becomes. Now, reputed platforms, as I say, impactful peer-reviewed journals. The second is means authentic online platforms. And when I say online platforms which are known to the journal public, at large. And I've written a couple of examples here. SCC Online, because SCC Online is something which is widely known to the law-based audience or the law-based professionals, bar and bench. You could another example could be live law, and so on and so forth. Then there are UGC approved journals, formulated by the University Grants Commission. But since now the same list has been scrapped, you could always have an option to go for the UGC approved journals. And last but not the least, the Scopus Index journals, uh, based upon their quartiles in their quality. Quartiles are the categories of the demand or the authenticity of these Scopus Index journals. Okay.
Rajat, I'm really sorry to interrupt you for a bit, if that
Yeah.
works.
No
Please.
problem. Yeah.
Guys, everyone who's on call, so this meeting was supposed to happen for like 1 hour. It gets over in 4 minutes. So as a result, I have shared the link for a fresh. I have shared a fresh link for a meeting. So if you guys could just transfer yourself to the new meeting, I think that works pretty much in our favor. I'm really sorry for the interruption. It's going pretty much well with the flow, and I think you all will benefit a lot from continuing with the session. So I have shared the link in on call messages. You can check it in your chat box on this particular Google Meet link, and you can join the next one, so that Rajat can also transition. It will take around 2 minutes to kind of share the screen that he's already doing, so that we can restart from where he has left. So I think that
Yeah.
works. Thank you so much.
Am I audible properly now?
Yes, sir.
Just give me a moment. I'm sharing my screen. Is it visible? Is my screen visible now?
Yes, Rajat. Yes.
Yeah. So now coming on to the second part of this session today, the paper presentations. First of all, I would give everyone an idea of what actually paper presentations are. So, I would say in simpler terms that paper presentations are an opportunity to present your research to a wider audience. As simple as that. But what is something that you have to keep in your
Yes,
mind
sir.
is there anything? Yeah. So, so paper presentations are the opportunities that you get as a researcher or as an academician or even as as a legal professional to present your own research idea or your own research based concept to a wider audience, and that is where you gain your you gain industry insights, and you can shape your research based upon the same. And the most important part that uh, you counter through it is that you become more presentable and you know how to do away with the stage fear. Slowly and gradually you get that confidence while you present that yes, this is something that this is something that I have worked upon, this is my research, and you get that confidence to stand out and deliver. So now there are certain do's and don'ts while you present your research. Now these are just 4 points that I'll quickly go through and make everyone understand that it's fundamentally very important to build the presentation, to structure the presentation around one central idea. Don't always go around multiple topics all at one place, because this gives the panel or the evaluator or the audience an impact or an idea that you are not clear on and thorough with your topic, right? So it's important that whichever point of your law you are researching upon,
Rajat, your voice is not audible. Rajat, voice is not audible. Rajat, try joining once more if possible. To others, am I audible?
Yes,
Susmita, am I
Yes.
audible? Okay,
Yes,
okay,
Dada.
Yes.
okay, okay.
Yes, sir.
There might be some glitches pertaining to Rajat's network, so we might just wait for him till he joins us back. In the meanwhile, requesting everybody to check the in call messages where you can post your questions if you have to Rajat, so that the moderators for today can pick up the questions accordingly. I do not know if we can accommodate most of the questions, but then, however, we'll be trying our best to do the same. So, if you have any questions, kindly write them down in the in call messages section that you find. You just need to click on the three dots and you find in call messages. Therein, you can type out if you're attending from your phone. Thank you so much for giving us your precious time on a Sunday morning, and let's please wait till Mr. Shandilo joins us back. Shalia, try talking to Rajat once if he has got himself into any glitch for which he cannot join. Shalia, just talk to Rajat once.
Yes, yes, yes. Okay. Um, we are sorry for the glitch. Let's wait till our guest comes for 2 minutes. Just wait for 2 minutes. Sir,
Is
now
it?
can we? Yes, sir.
Yeah. I'm sorry for the glitch. I don't know it happened in between, but no problem. I think we have not lost the audience. So I'll just continue. Okay.
Okay.
Yeah. Is my screen visible properly?
Yes.
Yeah. So I was talking about the things to avoid, right? So the things to avoid is that you have to be within the scope of your research paper or the presentation that you are giving. And the second important thing to avoid here is that while you're presenting, don't focus to animate your slides too much. When I say animate, there is no need to put in the animations that you have. There is no need to put in any cartoon or logo or any other sort of entertainment medium in your presentation. There are certain people who do it just to make it funny, but always remember that it is just a formal presentation that you're given, that you're giving in a confined setup and in a professional setup as well. Again, the most important thing, the next point, don't break the flow of your presentation. Always make sure that you present your idea in in the same thread or in the same flow that you've taken right in the starting, and always make sure to maintain that same amount of energy. Now, and the most important, again, one important point here is that don't read word to word. It is something that most of the academic community discourages, and this is where it displays that you are out of confidence and you are not aware of what you are presenting or what you worked upon. Yes. Now coming on to the most important third segment here, the moot courts. So see, moot court, I believe that being into law, most of us sitting here in the meeting today are aware that moot courts are uh, competitions where you argue upon a moot problem, an imaginary problem, okay, or an artificially created problem, I would say, and you argue as lawyers from both sides. There are two sides that we have to argue, as the petitioners and the respondents. And I would say that it is one of the most important exercise when it comes to law school, but because that not only it gives you a fair idea of the competition, means of the real world, but also it makes sure that you know uh, are prepared to be professionals for tomorrow. Again, coming on to the purpose, it gives you a systematic idea of how to conduct legal research. It gives you an idea of how to present your case, how to orally, argue as an advocate. Okay, and the third part is that uh, it makes you familiar with the real court experiences to an extent, right? I do agree that it may not give you the entire familiarity of the original code, but to an extent you understand that these are the procedures that have to be followed. This is the way you have to argue. This is something that you have to follow, right? While you are arguing, there is something called code demeanor which you have to maintain. So these are the important things, which I would say are the purpose and the importance of moot courts. The structure, to give you an idea about that, as I've written here, that it comprises of memorial submissions and oral rounds. And memorial submissions are the fundamental document that you submit when it comes to participating in the moot court. And the oral rounds is where you present and you get judged upon based upon the flow and the originality and the quality of your arguments. The do's in the moot courts is set realistic and achievable deadlines. Now take an example that you've done something Okay, and you've done something and you've made up your mind that based upon this, this particular problem, you like an area, and based upon that you've registered for a particular moot court. And now it becomes important to divide your target, or divide your work accordingly based on realistic deadlines. Don't uh, go on to set something which is unrealistic for you or unachievable for you. You cannot make the entire memorial in one day if you have to maintain and assure quality. So this is something that you have to look properly into, and always have good bonding with your teammates, because that is the ultimate unit that you are a part of, and that will support you in your entire journey while you are participating in the moot court competition. Now, be regular and consistent, which means that always carry, if you are having 15 to 20 days or a month, or let's take an example, couple of months, be consistent and do regular research. Don't leave it for tomorrow. Take one point at a time and then structure and research upon it accordingly. Okay, then the most important thing is structuring your arguments and aligning the same with the memorials. While you present orally, make sure that you structure your arguments based upon the issues that you have written or that you have researched upon in your memorial. Okay, now moving on, researching extensively. And here I would say that always use only credible sources for legal research, and don't use something as a source or as an authority which you are not sure about, and which you are not sure of its authenticity or its credibility. Again, and now moving on, courtroom demeanor has to be followed. Don't ever argue with the judge. Okay, and always make sure that your tone is humble, you know what you are saying, and don't ever argue or don't ever confront the judge, because that is something that can go against you. The don'ts: don't ever lose the spirit within the team. Always make sure that your team spirit is up, even if the things don't go against you, means don't go in your favor. Then again, moving on, don't break the flow of arguments and use authentic authorities only. This is something that I've already highlighted. And the last point here is that don't compromise upon course integrity. Always try to make sure that whichever question is being asked upon, you are able to deliver its answer efficiently. You are maintaining the demeanor of the court. You are not confronting anything. Your tone is polite and humble. And it's always important that there are certain parameters that we also keep in mind while we are in a moot court, that always think from the other side of the table. Okay, and this is where my practical experience would come in handy, since I have been a part of 18 moot court competitions as a judge. So I can share my own experience that we as judges, often times we understand that he or she, whoever the counsel is arguing before us, we understand that that person might or might not know each and everything, but at times we do ask certain questions to check the confidence, and to check the the kind of I would say um, the kind of trust that he has on himself and his team. Okay, so always remember, if you have not answered something, that doesn't necessarily mean that you have ruined your chances or something like that. There are times when your confidence is also checked upon. Always make sure that whenever a judge is asking question, always greet that judge that yes sir, dear, respected lordship or respected ladyship. Never use dear. Dear is something that you use with your friends or your professionals of your same age. So always use respected counsel, or respected lordship or ladyship. Thank you for your question, and then you start answering the same. So this gives a positive impression. Always address the bench collectively as your lordship or ladyship only after the permission, because this is something we as judges look forward to. And always, this is some very important thing, that most of the teams at times miss, that whenever you are citing your prayer, always make sure that you stand and cite. Okay, so these were the things, because these are the parameters that you're, apart from your arguments and your quality and that you present, these are some of the insights, practical insights that no one actually tells you, but these are some things that are getting noticed while you argue. So this was it from my side. Now if anyone has any questions, I'm open to questions as well.
Thank you so much, Rajat sir, for an enriching and power-packed presentation, for your insights, sir. Your insights have truly demystified the process of legal research, paper presentation, and most importantly, for moot court competitions. Sure, every student here feel a bit more prepared and a lot more inspired. Now we'd like to open the floor for questions, both from our list and from the audience.
Thank you so much, sir, for your insightful discussion on legal research and paper presentation. Now, I have believed that everyone has gained a deeper understanding on the matter of how to approach research with clarity, structure, and originality. As a law student myself, I found it very informative. To begin with this segment, I would like to ask you, sir, what are the difference between real court proceedings and moot court competitions, and how should the students approach those differences while they are preparing?
Okay. So see, when you approach a real court, right? First of all, the most important thing is that you understand that it's a real court, and it's not an exercise, or it's not a competition going on. This is the fundamental difference. And when I say this, it is because that you have to understand that it's not a fictitious problem that you're dealing with, right? It's something which has something at stake, at least someone's life, someone's property, someone's money, or and so on and so forth, depending upon the nature of the case. So now we when you demarcate between real court proceedings and moot courts give you a as I mentioned in my presentation also, that it gives you a confined idea of what actually court experience is. But when you go into the real court, you understand that there is something called filing, there is something called taking dates accordingly, waiting for the judge for hours, okay, maintaining your schedule accordingly, managing your dates. So this is something which is not a part of moot court. But as a real lawyer, when you go into the real court setup, you understand that all these background procedures, the quality of your arguments. If you could say that, let's take an example, if you are arguing in a moot court, okay, and you say that pardon me lordship or your ladyship, I am not aware of this particular fact. But see, there we understand you will only be deducted with your marks. But imagine a situation where it's a criminal matter and you say that I'm not aware of the fact. Okay, your client might be costing his life. So that is where this fundamental differentiation comes into picture, that the margin of, in my opinion, I would say that the margin of error can be there in moot court but not in real courts. So the first important thing is that you need to understand what a real court and a moot court is. Number two is that you need to be familiar that it is not something which is merely a competition. And number three is that you will have to understand that no matter what, you have to be well prepared, and there is no margin for error when it comes to real court proceedings.
Thank you, sir, for your explanation. I have one more question that most of the students face actually. How should students prepare for a moot court from starting the understanding the problem and writing memorial after that oral argument for that oral argument? How should they prepare?
Means the entire flow, right?
Yes, sir.
So see, when the fundamental thing is that whenever you are, wanting to take a part in the moot court competition, always be thorough and always uh, read the moot court proposition at least 4 to 5 times right in the starting. Now, why I am saying that you read it multiple times is that you will have an idea of, you know, what it actually wants to convey. What are the issues that can be framed? At times there are issues which are already framed, but at times there are competitions where even have the liberty to frame your own issues. And also there are competitions which ask the participating team to identify the issues and then frame accordingly. Okay, so once you have read the problem, you have made up your mind that yes, I am going to participate in this, then comes in forming the right team. Because what the in the formation is, I would say, the fundamentally most important part. Because wahi log hain, these are the people that will help you, that will assist you in the entire course of the competition, in the entire flow of the competition. If you are not well in good terms with your team, I believe that you have already lost in a certain way, because the flow and the trust that you have on your team partners or your co-counsel, as we call in technical language, would certainly affect your progress. Number three is that when you have made up the team, now it is important that you go about with researching and you go about with the structure of drafting the memorial. Now, when you've identified the issues, it's important that you structure them well. And when you structure, always make sure that you, maintain the flow. When I say flow, that let's take an example. If we have to argue upon the test of reasonableness in the constitutional law, so I would first of all go on to explain the concept in a paragraph or two. Then I will take an opportunity to, break it down to the other aspects. What has been its jurisprudence, what has been its development, and what all the problem is asking. Relating is also important. I'm not saying only go on with the theory. Relation is the most important thing. The application is the most important thing in legal matter. Now, after you have prepared your memorial, it also becomes important for you to present your arguments, right? Always be humble, greet the judges well, and always understand that there are not every judge or not every bench that you face is of the same nature. Some might be humble, some might be very strict. Okay, so this depends, and it becomes very important for you to actually understand the mood of the bench. This is something which I'm saying on an informal note, but when you understand, you must have understood and seen at times while your internship or your court experience, there are lawyers who often at times, and Dada would agree to it on agree to me on this point, that there are situations at time where counsel say that this particular judge is not in good mood today, don't go to his court. So, if you are a good counsel or if you're a good researcher, you'll understand that what kind of questions are going to come at me. So when you are well prepared with the flow and the you have anticipated certain questions, and fortunately you argue on your same lines, I am sure that this is going to help you. And always, once you've concluded your arguments, make sure to take a constructive feedback from the bench so that you can improve upon the same in your future course of competitions.
Thank you, sir, for breaking it down so clearly.
Yeah.
I have heard many students worry that they even know the law, but stage fear affect them. Like they know the law, but they have an anxiety. How can they overcome that anxiety and prepare the presentation with confidence?
See, I'll tell you with my personal experience. I was, it happens with everyone. Okay, everyone, even at a point, I was, fearful of being judged upon my, the way of my presentation and everything. And it was important that we have to overcome that, as you mentioned. So what my technique was to stand in front of a mirror and practice. Okay, be conscious of what you are speaking. Time your presentation well and then execute. You might fumble one time, two times, 10 times, doesn't matter, but be regular on your practice and start giving pauses in between. It's not a train going on. Okay, unfortunately we have had a short technical glitch as well, but it's important that you carry on with the same flow, right? Let me give you my own example. I was giving a presentation, right? Unfortunately a glitch happened for a minute or two, but it's important that we cover that accordingly. It's nothing to be hopeless about, because see, these are just natural things that happen in between. So no matter what, if you are even starting, you have to maintain the flow. Okay, and this could be overcome by I would say that practice regularly, stand in front of the mirror and then say, yes, I can do it, I have prepared, this is my presentation. And always remember, be commanding when it comes to your mindset. Okay, you should not be aware of the fact that this is a particular set of audience which is sitting here to just judge me. Okay, and I might not be good enough, but instead my my psychology here is that yes, I have been a part of this conference to present my own idea, right? These whichever the audience is sitting is here to listen to me. I am the master of this audience right now, and that is where the game changes. You completely transform your own fears into your confidence, right? Take it this way. Why can't we have it the opposite way around? Yes, I am a part of this conference, it is my turn and it is my audience. So ultimately, I have to command them in my own flow and my own way. So this is where the difference comes in, right?
Okay, got it, sir. Thank you for your tips. Now I want to handle
Uh,
over to my co-moderator Salyanas. If she has any question, then please feel free to ask our speaker, sir.
Thank you so much, Rajat sir, for your answers, and thank you so much, my co-moderator Shushmita. I would like to ask few more questions, then we'll be ending up the session soon.
Could you ask a
Uh,
question? Hello, Shalya, am I audible? Before you ask a
yes,
question,
yes, yes.
am I allowed to ask a question to Rajat?
Sir, anytime.
Sure, sure,
Please go.
sure.
Okay.
Go.
So break it down a little bit pertaining to the fact as to how a researcher should approach the moot, because in many of the moots they are not asked questions generally, like in those that you have went as a judge or I have went as a judge for all these years. The point is just break it down to them if possible as to how the researcher should approach the moot and what questions he generally must be ready with within the scope of the uh, the proposition or beyond the scope of the proposition. So just break it down a little bit before Shalia takes up her part and we wrap up henceforth. Thank you.
Okay. So from a researcher's point of view, I would say that it's important that being a researcher is a very, I would say, it's a cumbersome task. And why I say it's a cumbersome task, because the entire the presentation of your memorial, the research questions, the research quality, it eventually goes on to drop to your researchers, to be your researcher's responsibility, right? So when you approach a particular moot court as a researcher, right, you have to be very, very thorough with the problem, because see, the councils have the liberty to argue and say that, sir, this is something that I might not be familiar with, but as as a researcher, you are expected to know each and everything. They would say no. The bench will definitely ask you that this is something that you have been the researcher. It's your responsibility to research upon things, and yet if you are not able to answer, this is your fault. So the correct mindset and the correct approach should be that you should be ready with the anticipated questions that the bench might ask you. Let me give you an example, that as I've told that I've given the example previously, that if you're talking about reasonable restrictions, right? So you should know each and everything about reasonable restriction. If the issue is asking you to elaborate upon the same, it's important that we have an idea as a researcher about each and everything regarding that concept, in which section it is given, what is the concept, okay, how far are the reasonable restrictions applicable, what are the landmark authorities. Anything could be asked by the judge or the bench, okay. And most importantly, there is something called a researcher test that every researcher has to go through. So you should be well versed with each and everything. Read your moot proposition line by line, and also make sure that you are not supposed to argue, but you are expected to know something which is between the lines, okay. And I would say even beyond the lines, because the speaker might or might not be asked about the jurisprudence, but you as a researcher are expected to know even the jurisprudence of it. So it's about the flow, it's about the core issues of your problem, it's about the jurisprudence, okay. It's about your knowledge of the dais while you're even not arguing, okay. And it's about the coordination of your team. While your counsels argue, you are responsible to pass them or convey to them any sort of information that might be of utility or help within your argumentative setup while you argue. So this is my take on this.
Thank you, sir. Once again, and a few more questions. Like, basically, as a law student, I have also faced that. So that's why I want to ask. And I think that is the initial question which a student face. Basically, as a first or second year law student, how can one start doing legal research without feeling overwhelmed? And like that, how to start, basically, to initiate.
To start legal research, you have to start reading, number one. Because when you read, you get a sense to inquire about things, okay. Let me take an example that someone who's not at all versed with what legal research is. So it's important that you first read things, okay. As first year or second year students, we are often exposed to law of torts, law of contract, some basic legal subjects. So I would say that always read, number one. Number two is that the correct way of approaching is that you write something. And when I say that, there might be a natural question that you are saying that I've been asked about legal research and I'm saying write something. Why I'm saying this, there is a definite reason behind it. That while you write, that you will be needing information, and when you need information, you will definitely research upon it. You will definitely inquire about it online, offline, through books, journals, or whichever source you have, okay. And as first year or second year students, no one expects the student to be perfect, but it's about developing that over time, right? As I told that I started writing and researching by writing blogs earlier on when I started, and that too random blogs for websites on various topics, multiple topics, and on multiple areas, okay. Now what that does to you as an individual is that slowly and gradually you understand that, okay, I'm writing on this particular thing, okay, I have to research upon things. And now coming on to specifically research, always make sure that your research is done from authentic sources. When I say authentic sources, it might not be possible that a first year or second year student be aware of what authentic sources are. But then this is where as a mentor, as a teacher, as a senior, the role of professors and peers comes in. Always be in touch, build your network, and understand that it's not about only you, it's about learning from everywhere you get. And now when you know about resources, when you know about, if you can ask your professors, you can ask your seniors always, right? And once you know that now these are the sources, then you can shift your approach towards researching upon a pinpointed source of law, over a point of law through various sources.
Yes, yes,
Yeah.
Thank you. Thank you. And again, which are the sources which should use for conducting a good legal research. And as we all know that we are into a digital era, we use AI. So how to use it effectively as well.
Okay. So I'll take a slightly, unconventional take on this. See,
Okay.
since means the AI is in a developing stage, you cannot trust it completely. Even though it can, it can help you, but I am sure most of us in the meeting would agree that it cannot replace humans, at least as of now. We have had multiple instances of the legal proceedings taking place against each other, right? Multiple copyright infringement cases. Okay, and there I was reading a couple of days back that there has been an instance in the US court where there has been an institution of criminal proceedings against a lawyer who has used fake case laws in his draft, which were generated by AI. So, see, you can use AI, but you cannot completely and blindly rely upon it. And I am very proud in saying that I don't use AI at all. I'm very proud. It takes time. It takes a lot of time. I know what can be done in hours. It takes days. But in whichever conference I take part or whichever writing I contribute to, I don't use AI. I'm sure that some of you might be surprised also, but I don't use it. And this is something that I always advise, that even if you are using, I'm not saying that if I don't use, you also don't use, or there is no use. I'm not saying, but use it effectively. Let's take an example. If you want to integrate AI, and take its help while writing a research paper, okay, you can maybe directly artificial intelligence system, maybe chat GPT or Gemini or some other source to structure the paper for you, okay, to give you a flow of ideas to to help you understand. But always make sure that you cite things on your own. You check its authenticity. Don't use use GPT for referencing, because at times your flow gets disturbed, your authenticity gets disturbed. At times there have been repeated instances where there is a case scenario of fake case laws being generated by AI. So these are some of the things that you need to take care of while you use AI. Use it for structuring, use it for guidance, but not entirely for giving it a random question and seeking an answer. And even if you're seeking it for an answer, please make sure that you at least Google and double check the information for authenticity.
Sir, as you said, we should not rely on AI. So what are some effective tools or methods for conducting good legal research?
Effective tools or methods? Yes, very good question. See, at the student level, I would say that it's a gradual process. You evolve over time. Okay, so if I have to begin with, I started my legal research by Indian Qanun. Being a student, first year law student who doesn't know anything and everything. Okay, but if you ask me professionally, Indian Qanun doesn't hold that professional value. It has zero value. Okay, but this is something that we got to know gradually by learning, right? So when it comes to effective sources, as I mentioned, SCC Online is one of them. Okay, Manupatra is the other, which are authentic and which hold value. Okay, then there are multiple platforms. There is a platform called CaseMine, right? Okay, but these, I would say that if you specifically want to stick to research, always use authentic sources ranging from SCC Online, Manupatra, Hein Online. These are some of the sources which you could use as a student. Okay, so it's important that you understand that there are different sources, but again the authenticity is a question. You cannot produce a citation of Indian Qanun in real courtroom proceedings. You will be questioned immediately that Indian Qanun is just a random website. How do you present your case through it? So it's important that you understand. And on the other hand, when you go with SCC Online, it's something that it's widely acceptable and it's it's a fundamental platform for citations and your research material. So as a student, it becomes important to bifurcate and demarcate upon the authenticity. So these were to name a few, and then it depends. As slowly and gradually you grow, you understand that there is a huge difference between Indian Qanun. I'm not defaming Indian Qanun in any way, but as a researcher, I'm saying that you go on to learn with time.
Okay, sir. Okay, so one last request. Lastly, would you please open to share any of your own published papers so that
Yes.
students can refer for improving
Yes.
our structure and analysis?
Yes. Just give me a moment, okay? I'm
Okay,
sharing my.
sure. Take your time.
I'm sharing my screen.
Rajat, I have a question from you. I have a
Yeah.
question to be answered from you.
Yeah.
This
Please.
might sound funny, but the question is, you said you are a criminal jurisprudence expert working on AI. If Professor B.S. Chimney would have been there, he would have asked you, Rajat, how are you working on AI and criminal jurisprudence without using AI? What? That's the exact approach. Because for PhD interviews, such questions might just be asked anyway. But
Yes.
I I am really thankful that you took off time for the firm and for all of us to kind of conduct this, and hopefully my juniors could keep up to their promise of coordinating with you with everything. I hope they could coordinate with you and accordingly move things forward. And we hope that there will be more collaborations in the future. Before you
Sure.
start sharing it, I'll just really wanted to extend my regards, and I would like to thank you as my younger brother, my colleague, my co-author for a long time. Thank you so much for the same. Hope they will learn a lot from you in the future as well when we have further, enterprising events with you as a part of the chambers and as a part of the chamber. So thank you so much, Rajat. You may
Thank
continue sharing the same.
Yeah. So, Dada, it's a very fundamental thing that I'll say, and I'm very thankful that you brought this up, because I've been asked by Professor Chimney himself when I was discussing the same idea that you were talking about AI in criminal jurisprudence or criminal justice system without the use of AI and integrating the same into your research. But then again, since I am a full-time researcher and a PhD scholar, I would say that, see, integrating AI is not a problem, but relying upon its authenticity, at least for now, is right. So the technical, I would break it down into two parts. That the technical integration of AI and the academic integration of AI hold, they're two different pathways altogether. When we talk about the since it's my area of interest as well, I'm researching upon AI and criminal justice, as you mentioned. So see, technically integrating it, like we talk about, let's take an example of the e-courts project, which is used technology, the Supas and Subas software that are using and integrating AI into judiciary. So see, the technical integration is something that has the human oversight over it. But when you talk about the use of AI into academic writing and academic research, the entire oversighting authority is we as an individual, right? It is our research, it's our piece of intellect that we are producing. So there you have the oversight of a complete authority that has been authorized, the government per se, right? But here the ultimate authority is us. I know that the people who are there might be surprised when I said that I don't use AI. Okay, it takes time, it takes a lot of time. Something which might be written in an hour, I might take a day or a two for the same. But again, I don't want its academic integration to an extent that it produces any sort of misinformation or any sort of less integrity based material from my end. Because when you talk about AI's technical integration, the government has an oversight over it. The government has control, command, and authority. But in our case, as a researcher, it's completely us and only us who's responsible. So tomorrow, if something comes up and I am being questioned that you used AI and you did not see into it, or you used AI or you did not set it according to the format. So I don't want that to happen, and this is the reason that I say. I'm not saying that eliminate AI. I'm not saying about its elimination. You talk about structure, you can use AI, okay? Because since it's very highly accurate as well. You talk about structuring, you can use AI. You talk about the basic outline, you can talk, you can use AI. You talk about finding sources, books, materials for you, you can use AI. But the ultimate oversight, I would say, has to be done by us as an individual, as a responsible researcher.
Okay, thank you, sir. Now we can move forward with your paper.
Yes. This is something that I like to share. Yeah. Just a moment. Is my screen visible?
Yes, sir.
Yeah. So this is the dissertation that I've prepared in my LLM. It's very close to me since I got my degree through it. Okay. So first of all, you could see that there is a title, and I am sure that everyone who's in the meeting today might get a fair idea of what I want to present through this. This is the title. It was Calibrating the Scales, a comprehensive study to reconceptualize criminal sentencing in the Indian legal landscape, where I have entirely talked about criminal sentencing at length in my dissertation. And now moving on to the format, it's just to give you a fair idea. These are the dedication pages and everything. I'll just skip that. Yes. So now coming on to the table of contents. Now, when you look into my introduction, the first part of it, okay, it is chapter 1, which starts with an introduction, and then it breaks down to different segments, which I have mentioned as the structure of. I talked about the primary sources, the secondary sources, right? So this is the structure. First of all, comes in the introduction. The problem statement means the actual problem that you are wanting to address through your research, and you will be addressing through your arguments or through your flow of paper or any academic writing that you produce. Okay, now moving on to then again 1.3 talks about the literature review, where you mention the primary, secondary, and all the leading scholars also. When I say leading scholars, this means that the national and the international authors that are already working upon your area of interest, and citing those and referring to those will give you a fair edge and quality over your your work that you produce. So this is it. Now moving on to the second chapter, you could see that I have categorically numbered every heading to give it a formal structure. Right, I'll take you. This is the third chapter that I wrote. The fourth one and the fifth one, as I said, the last one should be your conclusions and suggestions, and that also I've categorically mentioned into concluding remarks, suggestion, and I've then specifically made sure that every suggestion has its own mention within the table of contents only. And then again the bibliography part, which is important, where you demarcate in the primary and secondary sources, and here it is. And this is done after the conclusion and suggestions that you propose through your research. And this was the flow. This is chapter 1 that I wrote. This was the introductory part. Okay, the problem statement. You could see that, if you could see my problem statement, and that I'm talking about the difficulty which is there when it comes to sentencing, that in India there are no specific guidelines as to as far as sentencing is concerned. Okay, so this is my problem statement, where I mentioned that this is something as an area or as a question of law that I want to research upon. That then comes in my literature review, where I've given a short introduction, and then leading literature, and then I've divided into primary and secondary. All the committee reports, you could see the Malimat committee and the Madhav Menon committee that I've mentioned. And then I have moved on after using on all the primary sources. I've gone to the secondary sources, the research papers, the books that were there. So this is something that I used. And then leading scholars, as I mentioned, all the scholars that have done or written upon in your area are mentioned. Okay. And if you use graphs and certain pictures also, this also gives you slight edge, I would say, but always make sure that you don't insert cartoon in your paper. Always insert formal structures. Now coming into the research questions and the research methodology, which is important. So you have to be very specific in what kind of research questions you propose, because that determines the authenticity of your your write-up or your work. And then comes in the research methodology that I talked about. In this, since it was a doctrinal study that I conducted, so I've written specifically over that there is the doctrinal method of legal research that I've used as a part of this dissertation. Now these are my chapters. Now I've talked about models of sentencing and everything. And now coming on to the conclusory, means the conclusion part, the concluding remarks. Just a moment. This is again a graph that I have incorporated. And whenever, please make sure that if you are inserting a picture, always mention the source. As you could see, I've taken it from the UK Parliament session of 22-23, so I've mentioned the same. Now, concludatory remarks, suggestions, I have broken down, and this should be the ideal format, right? Since I was confined by the word limit of around 10,000 words, so I have to conclude within the same, but it is very flexible when it comes to other platforms. So this is the thing. I've given a fine conclusion, and based on, I've broken down my suggestions specifically, that there is a legislative framework which is needed. Okay, there is a commission which is required, and also there is training required, and again judicial survey and every other thing that I mentioned. And again, after that, eventually I've gone on to the bibliography. You could see there is an extensive bibliography that I've mentioned. Okay, yes. So these are the important things that we have to follow while structuring a research paper. I hope I have been clear and I've been able to
Okay, sir. Thank you so much for sharing your.
Yeah, I hope I've been able to clarify the format.
Yes. Thank you so much for that.
Yeah.
Now, Sushmita will end up the session. We'll wrap up the session soon.
Before we wrap up, now we will open the floor for the audience question. If anyone has any question, please feel free to raise your hand or drop it in the chat box.
I guess there is no more question.
Okay, it looks like we don't have any question. Perhaps our speaker sir already explained everything so clearly. Once again, thank you so much, sir, for your time, your guidance, and your encouraging words. Thank you so much, sir.
Yeah, and I'm
And so
really
helpful.
sorry for the technical glitch that happened in between. I'm really sorry, and I heartfully apologize for the same. It just happened. I don't know.
Thank you, sir, on behalf of CPC Satya Incorporated Law Chambers and everyone attending today. I sincerely thank you for your time, for your clarity, and most importantly, your generosity in sharing your journey. Thank you so much.
Thank you so much, sir.
I am thankful, in fact.
Before we end, thank you so much, Rajat, for your time and for the bad questions that I generally ask you in general for the so many years. But this has been really an enterprising, journey, because I have known Rajat ever since he was a UG student and now a senior scholar at Symbiosis. So the point is, he was just like all of you, and he just put in enough hard work to do research, because as he already pointed out that research is not only needed for doing higher studies in academics, in legal academia, higher legal academia, but also for doing your everyday court practice. Because if you do a policy practice or if you do something like a regulatory litigation, research should be your core base, based on which you have to use your manupatras and SCCs every day. So there is nothing called a practice and a praxis of academics in legal academia. It's everything coupled together. Law is the most interdisciplinary of all subjects present. So that's how academia and legal practice must integrate, and hence I started off the this series of lectures that we'll have henceforth with Rajat, because he's the best person to start this integration, to be very honest. Thank you, Rajat. Looking forward to more enterprising events with you, not only events but long term courses that will benefit all of us. And that is how we should wrap up by today. Thank you so much, everybody, for your time. And thank you so much to Shaleha, Shushmita, for being wonderful moderators. This is a start of your journey, and hopefully it will take it forward. Also, thanks to uh, Watutri and Shomo for being amazing technical hosts for the session, and to Sneha, Prutiti, everybody working with me for some time on research, on policy. I hope that we will have something in the future that will Bondhoni, everybody who's present here. Also, did I miss anybody out? And everybody who intends to join my chamber later, now or later, I think we'll have a good time doing things that others aren't doing really around when it comes to integration. So, thank you so much, everybody. Have a nice Sunday. Rajat, I'll catch up with you after
Sure.
this later. Take care. Thank you so much, Rajat. Thank you so much,
Thank you so
everybody.
much, sir. Thank you.
Good day.
Thank you so much, sir.